2 years ago, I got a phone call from a woman I'll refer to as Patricia. Patricia wasn't reaching out about her own situation. She was calling about her elderly mother, a 78-year-old woman named Ruth, who had spent the past 44 years living in the same home, a home that was entirely paid off. No outstanding mortgage, no lien, no financial obligation of any kind attached to it. Ruth had spent the final 3 years of her life receiving care in a nursing facility. That care had been covered through Medicaid. The family had handled everything properly. They completed the Medicaid application correctly. They disclosed every relevant detail truthfully. They followed every instruction they were given. Ruth passed away quietly 6 months before Patricia picked up the phone to call me, and then something arrived in the mail. Not a sympathy card, not a routine government form. A formal legal notice from the state informing Ruth's family that the state was initiating a claim against Ruth's estate, specifically targeting her home, in order to recoup the cost of the Medicaid benefits she had used during those 3 years in the nursing facility. The total amount the state was pursuing, the amount it intended to collect from the home Ruth had lived in for 44 years and fully paid off, came to $227,000. Patricia was in tears when she called me. She said, "How can this even happen? My mother owned that house outright. She paid it off herself. She left it to us. The government doesn't have the right to just take it." I had to share something with her that I have had to share with far too many families across far too many conversations like that one. Yes, under federal law, through a program known as the Medicaid Estate Recovery Program, the government can do exactly that. And in 2026, with revised state-level recovery regulations expanding what qualifies as a recoverable asset across multiple states, the financial exposure families face is greater than it has ever been before. But here is what I also told Patricia. There are legitimate legal strategies, specific, well-documented, and time-sensitive strategies that could have shielded Ruth's home entirely. Strategies that Ruth's Medicaid counselor never brought up, that the nursing home admissions team never disclosed, that the state Medicaid office certainly never volunteered on its own. Strategies that genuinely work, but only when they are put in place before Medicaid benefits ever begin, not once the process is already underway. In this video, I am going to walk you through everything Patricia needed to understand before her mother ever stepped foot inside that nursing facility. What the Medicaid Estate Recovery Program actually is, why a fully paid-off home is specifically and significantly more vulnerable than most families ever realize, the 5 legal protections that are available right now, and what steps you need to take if you or a loved one owns a paid-off home and there is any realistic chance that Medicaid-funded long-term care may be needed down the road before it becomes too late to do anything about it. This video is for every family that has worked an entire lifetime to pay off a home. Stay with me. Before I take you through the 5 protections, I need you to fully understand the scope of what the Medicaid Estate Recovery Program actually is, because the vast majority of people have never encountered it. And the families who learn about it for the first time are almost always finding out after the point where any meaningful action could have been taken. Here is the federal legislation that created this program. In 1993, Congress enacted the Omnibus Budget Reconciliation Act, commonly referred to as OBRA 1993. Tucked inside that legislation was a provision mandating that every state create a Medicaid estate recovery program. The program functions like this. When a Medicaid recipient who received nursing home or long-term care benefits passes away, the state is federally obligated to attempt to recover from that person's estate the cost of the Medicaid benefits they received during their lifetime. The estate includes all assets the person held at the time of death, and for the majority of seniors, the single largest asset in that estate is their home, The program specifically targets Medicaid recipients who were 55 years of age or older at the time they received benefits, which includes virtually every senior who qualifies for nursing home Medicaid coverage, and it applies regardless of how long the individual owned the home, how completely it was paid off, or what wishes they had about leaving it behind for their children. Here is the figure that truly illustrates how serious this program is. According to the Kaiser Family Foundation, states collectively recover approximately $700 million annually through Medicaid estate recovery efforts. That money comes directly out of the estates of seniors who believed their homes were protected assets. Most of those seniors had no idea the program existed. Most of their families discovered it the exact same way Patricia did, through a letter that showed up after the funeral was over. Here is the particular danger in 2026 that makes this more pressing than ever before. Several states have revised their Medicaid estate recovery rules this year, broadening the definition of a recoverable estate to capture assets that were shielded in certain states previously, including particular types of trusts, joint ownership arrangements, and life estate interests. The window for implementing protective strategies that were available just last year has grown narrower in multiple states, and the paid-off home is the primary target because it is the asset with the greatest equity, the clearest title, and the most direct path for the state to pursue recovery. A home that still carries a mortgage has limited recoverable equity available. A home that is entirely paid off has its full value exposed to the state's claim. If you or someone close to you owns a paid-off home and there is any possibility that Medicaid-funded long-term care may be needed at some point in the future, what I am about to share with you is the most critical legal information you will come across this year. Hit subscribe right now. This channel exists to ensure families have access to this information before they actually need it, not after the letter arrives in their mailbox. Now, the 5 protections. Protection number 1, the Irrevocable Medicaid Asset Protection Trust. This is the most thorough protection available, and the one that, when applied correctly and with adequate lead time, can fully shield a paid-off home from Medicaid estate recovery. Here is how it works. An Irrevocable Medicaid Asset Protection Trust, sometimes referred to as a MAPT, is a specific category of trust into which you transfer legal ownership of your home. Once the home has been placed inside the trust, it is no longer legally considered part of your estate. You are no longer recognized as the owner in the eyes of Medicaid. The trust itself holds ownership, and assets owned by the trust at the time of your passing are generally not subject to the Medicaid estate recovery claim because they fall outside your personal estate. You retain the right to continue living in the home for the remainder of your life through a specific provision built into the trust agreement. Your children or other designated individuals are named as beneficiaries of the trust. You continue living in the home exactly as you did before. The difference is that the property now sits within a protective legal structure that removes it from Medicaid's reach entirely. Here is the critical timing requirement that most families overlook. Medicaid has what is known as a 5-year look-back period. Any transfer of assets, including the transfer of your home into a MAPT, made within 5 years of submitting a Medicaid application is subject to a penalty period during which Medicaid will not pay benefits. This means the MAPT must be established a minimum of 5 years before Medicaid benefits begin in order to provide complete protection. A family that creates a MAPT today, before any Medicaid planning has become immediately necessary, is in an entirely different position than a family that attempts to set one up after a nursing home admission has already taken place. Ruth's family could have created a MAPT 10 years ago. The home would have been completely protected. The $227,000 recovery claim would never have come into existence. The cost of establishing a MAPT through an elder law attorney typically falls between $2,000 and $4,000, depending on the state and the complexity of the estate, measured against a potential recovery claim of $200,000 or more. That investment carries one of the clearest cost-benefit ratios of any form of legal planning available. Protection number 2, the spousal protection exemption. This protection applies specifically to married seniors, and it is the most immediate and powerful protection available without requiring any advanced planning whatsoever. Under federal Medicaid law, a home is exempt from estate recovery as long as a surviving spouse continues to reside in it. This is known as the spousal protection exemption. If a Medicaid recipient passes away and their spouse survives them and continues living in the home, the state is prohibited from pursuing estate recovery against that home during the surviving spouse's lifetime. This protection is absolute and requires no legal action to activate. It takes effect automatically by operation of federal law, but here is where the protection becomes more complicated and where families consistently make errors that end up eliminating it. The spousal exemption protects the home only during the surviving spouse's lifetime. Once the surviving spouse passes away, the estate recovery process can resume. The state may then file a claim against the home for the cost of the first spouse's Medicaid benefits, and in many states, for the cost of the second spouse's Medicaid benefits as well, if that spouse also received them. The spousal protection is not a permanent solution on its own. It is a window, specifically the surviving spouse's lifetime, during which additional protective strategies can and absolutely should be put in place. A surviving spouse who takes no action during that window passes the Medicaid recovery problem along to their children without resolution. The correct approach to the spousal protection exemption is to use that protected window as an opportunity to implement one of the other protections on this list, ideally the MAPT, during the period when recovery is temporarily deferred. Used in this way, the spousal exemption combined with a properly timed MAPT can provide complete multi-generational protection for a paid-off home. Protection number 3, the caregiver child exemption. This protection is among the least recognized and most valuable exemptions within Medicaid estate recovery law, and it applies to a specific situation that is far more common than most families realize. Under federal Medicaid regulations, a home transferred to a child of the Medicaid recipient who resided in the home and provided care to the recipient for a minimum of 2 years immediately preceding the recipient's institutionalization and whose care demonstrably postponed the need for nursing home placement is exempt from Medicaid estate recovery. In straightforward terms, if an adult child moved into the family home or had already been living there and provided caregiving to their parent for at least 2 years before the parent required nursing home placement, the parent may transfer the home to that child without triggering the 5-year Medicaid penalty, and that home is protected from recovery following the parent's death. This is referred to as the caregiver child exemption, and it has 3 distinct requirements that must all be satisfied. First, the child must have actually resided in the home, not visited on a regular basis, but genuinely lived there. Second, the care provided must span at least 2 years immediately prior to the parent entering a nursing facility, not 2 years at some earlier point, but specifically the 2-year period directly preceding institutionalization. Third, the care must be verifiable as having delayed the need for nursing home placement, supported by medical records, physician statements, and additional documentation demonstrating that the parent would have required a nursing facility sooner had the child not been providing in-home caregiving. If all 3 requirements are satisfied, the transfer of the home to the caregiver child is protected, the home passes to the child, and Medicaid cannot pursue a recovery claim against it. For families where an adult child has been delivering in-home care, This exemption can be the deciding factor between the family home remaining within the family and the state reclaiming it through recovery. But the supporting documentation must be in place, and the transfer must be executed properly through an elder law attorney to confirm that every requirement has been met. Protection number 4, the sibling equity exemption. This protection is more limited in scope than the others, but it addresses a specific and reasonably common family circumstance. Under federal Medicaid rules, a home cannot be subject to estate recovery if it is transferred to a sibling of the Medicaid recipient who already holds an equity interest in the property and who was living in the home for at least 1 year prior to the Medicaid recipient's institutionalization. In plain terms, if a brother or sister of the senior holds any ownership share of the family home and has been residing there for at least 1 year before the senior entered a nursing facility, that sibling's interest in the home is shielded from estate recovery, and the transfer of the senior's ownership interest to that sibling can be completed without penalty. This exemption is particularly relevant in families where siblings have shared occupancy of a family home, sometimes a property inherited from parents, where one sibling subsequently requires nursing home care while the other continues living there. The sibling who has been residing in the home and who holds an equity interest may receive the nursing home sibling's share of the property without triggering Medicaid estate recovery. If this situation reflects your family's circumstances, even in part, it is worth scheduling a conversation with an elder law attorney to evaluate whether and how the sibling equity exemption applies to protect the home. Protection number 5, the hardship waiver process. This final protection is the one that matters most when none of the advanced planning strategies were ever implemented, and a family now finds itself confronting an active estate recovery claim, which is exactly the situation Patricia and her family were facing. Every state Medicaid estate recovery program is required under federal law to maintain a hardship waiver process. This process allows the estate or surviving family members to petition for a waiver or reduction of the estate recovery claim based on documented financial hardship. The hardship standards differ from state to state, but federal guidelines identify several categories of hardship that must be given consideration. The home is the sole income-producing asset of the estate, and recovery would eliminate that income stream entirely. Recovery would result in the heirs themselves becoming eligible for public assistance. The heir is a dependent family member who has been occupying the home and has no alternative housing available to them, and the value of the estate recovery claim is disproportionate relative to the total value of the estate. Here is what matters most to understand about hardship waivers. They are not granted automatically. They are not simple to obtain, and in many states, the waiver application process receives very little public attention. States have minimal financial incentive to make it simple to waive recovery claims, but these waivers do exist. They have been granted, and an elder law attorney with hands-on experience navigating the estate recovery process in your particular state can meaningfully improve the probability of a successful hardship waiver application. Patricia's family ultimately submitted a hardship waiver application. The state agreed to accept a reduced recovery amount, settling for significantly less than the original $227,000 claim based on the hardship circumstances the family was able to document. It was not a complete victory. Some funds were still recovered, but it was a substantially better outcome than if the family had simply accepted the original claim without any pushback. If you are currently facing a Medicaid estate recovery claim, do not pay it outright and do not disregard it. Reach out to an elder law attorney immediately and specifically ask about the hardship waiver process available in your state. Let me bring all 5 protections together one final time. The Irrevocable Medicaid Asset Protection Trust, the most comprehensive solution available. must be established a minimum of 5 years before Medicaid benefits begin. Typically costs between $2,000 and $4,000, measured against a potential recovery claim 10 to 20 times that size. The spousal protection exemption, an automatic federal protection that applies during a surviving spouse's lifetime. Use that window to put additional strategies in place. The caregiver child exemption. If an adult child lived in the home and provided documented caregiving for 2 years prior to institutionalization, a penalty-free transfer and a recovery exemption may be available. The sibling equity exemption. If a sibling holds a share of the home and has been living there for at least 1 year before institutionalization, their interest and a transfer to them may be protected. And the hardship waiver. If you are already confronting an estate recovery claim, the waiver process exists and can reduce or eliminate the claim entirely with the right legal support in your corner. 5 protections, every single one of them real, every single one of them available right now, and not one of them mentioned by the Medicaid office, the nursing home admissions staff, or the state agency that will eventually send the recovery letter. Ruth's family could not undo what had already happened. The window for protective planning had long since closed, but Patricia said to me, "If I had known any of this 5 years earlier, my mother's home would still belong to our family today." That is precisely why this video exists. Share it with every family you know that owns a paid-off home and has a parent approaching the age where long-term care may eventually become a necessity, because the 5-year look-back period means that the right time to take action is not when the need suddenly arises. The right time to act is right now, 5 years before that need ever shows up. The letter Patricia received arrived 6 months after her mother's funeral. The legal strategies that would have prevented it needed to have been in place 5 years before her mother ever entered the nursing home. You now know exactly what those strategies are. Use that knowledge before the letter arrives at your door. What happens if Medicaid denies a benefit application because of asset transfers that occurred before the 5-year look-back period was fully taken into account? Watch the next video, where I break down precisely how to appeal a Medicaid denial and the specific arguments that have successfully overturned those denials during administrative hearings. I will see you over there.